Don't move. Hands where I can see them.
I am Chief Justice. Lish is my home. Do you have a warrant to be on this property?
Just do what I said now. Yeah, that's what people say when they get caught somewhere they don't belong.
I belong here. You are standing in my driveway without legal authority to do so.
You don't look like you live in this neighborhood. Get your hands on the vehicle before I put in there myself.
Chief Justice.
Shut up, Ned! Shut up, Nafar!
Officer Furlong, I am giving you one opportunity to check them. Make a mistake, the state Supreme Court will never let you forget.
Shut up, Neymar! That's it. You're under arrest for obstruction.
Cap's careers ended after arrest of Black federal Chief Justice in her driveway without warrant. At 8:14 on a quiet Saturday morning in Oak Brook, the neighborhood was doing what affluent suburbs do on weekend mornings, breathing slowly and undisturbed. Sprinklers moved across manicured lawns. A dog walker made her usual loop. 2 houses down, someone was already backing a car out of a garage. The street was the picture of ordinary Saturday peace. Chief Justice Alicia Washington, 58 years old, stood at the end of her own driveway in a shining suit and black shoes, moving her recycling bins back from the curb the way she did every Saturday morning without exception. Her keys were on the porch. Her phone was inside. Her coffee was getting cold on the kitchen counter. She was doing the most unremarkable thing a person can do on a Saturday morning, on her own property in the neighborhood where she had lived for 14 years. She was the presiding Chief Justice of the state Supreme Court, the highest judicial authority in the state. The woman whose signature appeared on the certification of every peace officer operating within its borders. The judge whose written opinions shaped the constitutional framework that governed every courtroom, every arrest, and every use of force decision from one end of the state to the other. She had spent 32 years on the bench. She had written landmark rulings on Fourth Amendment protections that were still cited in law schools across the country. She held more judicial authority in her zip code than any other living person. None of that was visible to Officer Brett Furlong when he turned his cruiser onto her street and saw a black woman in a tracksuit at the end of a driveway that his instincts told him she had no business standing in. He did not run the address. He did not check the property records. He did not slow down and observe long enough to gather a single fact. He pulled to the curb, stepped out with his chest already forward and his voice already set to command, and walked toward the woman who had spent 3 decades writing the very laws he was about to break. What happened in the next 11 minutes would end his career in 48 hours, trigger a Department of Justice investigation that would take 14 months to complete, and produce a settlement that made state headlines for weeks. Hit that subscribe button right now, because what Officer Furlong said about her Supreme Court credentials when he walked her into that precinct is something you will not believe until you hear it yourself. Alicia Washington had not always been the most powerful judge in the state. She had been, before all of that, a girl from Memphis who read every book in the school library twice and asked questions that made her teachers pause before answering. She grew up in a small house on the south side of the city, the middle child of 3, with a father who worked at the postal sorting facility and a mother who did hair out of the kitchen on weekends and quoted scripture and Thurgood Marshall with equal comfort. They told Alicia from the time she was small that the law was either going to work for people like them or against them, and that the difference depended entirely on who was willing to stand inside it and hold it steady. Alicia decided early that she was going to be one of those people. She graduated valedictorian from her high school, earned a full scholarship to Vanderbilt University, and went straight through to law school at the University of Virginia, where she graduated in the top 3% of her class and was offered clerkships by 2 federal circuit judges before she had even packed her apartment. She clerked. She practiced. She litigated civil rights cases for 11 years at a firm that took the ones nobody else wanted, and she won more of them than anyone had expected, because Alicia Washington prepared harder than anyone in the room and stayed calmer than anyone in the building. She was appointed to the state bench at 41. By 47, she was on the state Supreme Court. By 53, she was Chief Justice, the first black woman to hold the position in the state's history. A fact that was noted in every article ever written about her, and that she herself mentioned only when specifically asked, because she was more interested in the work than the biography. In 5 years as Chief Justice, she had written rulings that were cited across the country. She had overseen the reform of the state's bail system, the restructuring of its public defender program, and the creation of a statewide accountability standard for law enforcement conduct that bore her name in the legal footnotes of 3 separate federal cases. She was, by any measure, the highest judicial authority in the state, and the woman whose signature appeared on the document that certified every peace officer operating within its borders. She was 58 years old, and on Saturday mornings she made coffee, put on her gray tracksuit, and moved her recycling bins back from the curb. She had done it every Saturday for 14 years. It took 4 minutes. It required no credentials and no title. It was simply what she did. She was rolling the second bin up the driveway when she heard a car slow down on the street behind her, and something in the way it slowed made the back of her neck go still. She turned around. Brett Furlong had joined the police department at 23 because he wanted, more than almost anything else, to be in charge of something. 12 years later, that want had not softened. It had only gotten more specific. He was 35 now, lean and sharp-jawed, with a way of carrying himself that was all angles and forward motion. He did not walk into situations. He entered them. He had been told by 3 separate supervisors over the course of his career that he needed to slow down, gather information, and lead with questions before conclusions. He had nodded each time and changed nothing. He was not stupid. That was the thing that made him more dangerous than the officers who simply didn't know better. Furlong knew the rules. He had studied them. He could cite department policy from memory and explain use of force thresholds in his sleep. He just did not believe those rules were meant to apply as a constraint on him personally. He believed they were tools, and like any tool, you used them when they were useful and set them aside when they weren't. He had been assigned to the Oak Brook Patrol District for 3 years, and he had decided within the first month that the neighborhood had a problem. The problem, as he described it to other officers in the break room, was that too many unfamiliar faces were testing the borders. He used that phrase more than once. He meant it every time. His stop record in Oak Brook told a story that no one in the department had bothered to read. In 3 years, he had made 41 stops in the district. 36 of those stops had involved black or minority residents and visitors. Of the 41 stops, 4 had produced any citation or follow-up. The rest had produced nothing. No crime, no violation, no legal basis anyone could point to, except for the invisible and uncounted damage done to the people who had been stopped and had driven home afterward with their hands still shaking. 8 complaints had been filed against Furlong since his first year on the force. 6 had been dismissed internally. 1 had resulted in a written warning that was placed in his file and never referenced again. The 8th was still technically pending, filed 3 months earlier by a retired school principal who had been questioned while gardening in her front yard. It sat in a review queue, unassigned. On that Saturday morning, Furlong was on his regular Oak Brook loop when he turned onto Alicia's street and saw a black woman in a tracksuit at the end of a long, pristine driveway, moving a recycling bin toward a house that his instincts told him she had no connection to. He did not check the address. He did not run any search. He slowed his cruiser, pulled to the curb, and stepped out with his mind already made up. He had never once been made to pay for that habit. That was about to change completely. Alicia turned and saw the cruiser at the curb and the officer already crossing toward her, and she took one quiet breath and set the recycling bin down. She knew this moment, not from personal experience. She had spent 32 years working inside the system, not navigating it from the outside, but from the hundreds of cases she had read, ruled on, and written about. She knew what this moment looked like from every angle. She knew what it cost people when it went wrong. She kept her hands visible. She stood straight. She waited. "Stop right there," Furlong said. "What are you doing on this property?" "Good morning," Alicia said. Her voice was the one she used on the bench, level, clear, and designed to carry without effort. "I live here. I've been bringing in my recycling bins. Is there something I can help you with?" You live here, Furlong repeated, the way someone repeats a sentence they don't believe. I do. For 14 years. My name is Alicia Washington. I am the Chief Justice of the State Supreme Court. She kept her hands still and her movements deliberate. I have identification inside the house, and I am happy to provide it. Stay where you are. He looked at the house, then at her, then at the house again. We've had reports of suspicious activity in this neighborhood. What specific activity? Alicia said. Someone matching your description was reported near a residence earlier this morning. What description is that, exactly? Furlong's jaw tightened. Ma'am, I asked the questions here. Officer, Alicia said, and the word was not sharp, but it had weight. You are standing on private property without a warrant and without reasonable, articulable suspicion of any specific crime. I am the homeowner. I am not required to answer questions I have not been given legal grounds to answer. She paused. What is your name and badge number, please? He told her. The telling of it seemed to irritate him. Officer Furlong, she said, I am asking you, professionally and clearly, to check the name on the property deed for this address before this situation becomes something you cannot walk back. I am giving you that opportunity right now. She watched his face. She had watched a great many faces from the bench over the years. Faces that were calculating, faces that were frightened, faces that were about to make a decision they would regret. She recognized what she saw in Furlong's face now. It was the face of a man who had been questioned and who was going to respond to being questioned, not with information, but with force. Hands on the vehicle, he said, pointing to his cruiser. I am not required. Hands on the vehicle. Right now. Alicia placed her hands on the cruiser hood. She was completely still, but her mind was moving fast, logging every second in the precise, ordered way it had been trained to do across 32 years on the bench. She was already building the record. The driveway security camera had been installed 4 years earlier. After a package was stolen from Alicia's porch, it covered the full length of the driveway and 6 feet of the sidewalk on either side of the property line. It recorded in high definition, with a timestamp accurate to the second. It recorded everything. Furlong ordered Alicia to keep her hands on the hood and explain what she was really doing at the property. Alicia told him again that she owned it. He asked for the address of record. She gave it. He asked who paid the property taxes. She said she did, and that the records were public and available through the county assessor's office if he wanted to verify them in the next 60 seconds. He did not verify them. I'm going to need you to reach into your pockets slowly, he said, and hand me whatever identification you have. Alicia reached into the front pocket of her tracksuit jacket and produced her State Supreme Court Judicial Identification Card, official, laminated, bearing her photograph, her title, the state seal, and an emergency verification number along the bottom edge. She held it out flat on her palm. Furlong took it. He looked at it for a moment, turned it over, and said, Nice try. This is a good forgery, but it's not going to work today. The silence that followed was absolute. That is not a forgery, Alicia said, and her voice had gone very quiet, the way it went in a courtroom when the room needed to understand that what was about to be said was not negotiable. That is an official judicial credential issued by the state of this jurisdiction. The verification number on the bottom connects directly to the state court administrator's office. I am asking you to call it. Furlong set the card on the hood of his cruiser. Turn around. Officer Furlong. Turn around. Last chance. I am the Chief Justice of the State Supreme Court, Alicia said. My signature is on the document that certifies your right to carry that badge. If you place those handcuffs on me, you are not arresting a citizen. You are assaulting the judicial branch of this state's government. I need you to understand that before you take another step. Furlong reached for the cuffs. He spun her toward the cruiser, and the knee of her tracksuit caught the edge of the front bumper on the way down. The judicial ID card slid off the hood and landed on the driveway pavement. He left it there. The security camera recorded the ID on the ground. It recorded the handcuffs. It recorded Alicia straightening up as much as the cuffs allowed, her chin level, her face composed. It recorded all of it in high definition, with a timestamp from an angle that captured Furlong's face and his badge number simultaneously. By the time the cruiser backed out of the driveway, Alicia's neighbor across the street, who had been watching from her porch since the cruiser first pulled up, had already taken out her phone. The Oak Brook Police Department's main precinct on a Saturday morning was quiet in the way that small, well-funded suburban departments are quiet. Clean floors, low noise, a desk sergeant reading a paperback with one eye on the door. That desk sergeant was a 20-year veteran named Howard Price, and the paperback went face down on the desk the moment he looked up and processed what he was seeing. He knew that face. He had seen it in the State Bar Association newsletter, in the local paper at least 4 times in the past 2 years, and on the framed photograph that hung in the courthouse lobby, 2 miles from where he was currently sitting. He also knew, because he had been in law enforcement for 20 years and paid close attention to the documents that governed his profession, that the woman currently walking through his precinct door in handcuffs was the person whose signature appeared on his own certification renewal. He stood up. "Furlong," he said, in the voice of a man diffusing something. "What have you brought in?" "Trespasser, suspicious activity, obstruction," Furlong said, moving toward the processing area like it was any other Saturday. She was on the property at 4140 Elmwood, claiming to be the homeowner. Had a fake ID that she claimed was a judicial credential. Howard came around the desk. His eyes moved from the ID card, which Furlong had placed in a small evidence bag, to Alicia's face, and he performed, in under 3 seconds, the same silent calculation that every officer at every precinct in 3 previous stories had performed. The calculation always came out the same way. "Furlong," he said, "stop walking." Furlong stopped. Howard looked at the ID in the bag. He looked at Alicia. "Ma'am," he said carefully, "can you state your full name for me?" "Alicia Washington," she said. "Chief Justice, State Supreme Court. The verification number on that credential connects to the State Court Administrator's office. I would recommend calling it." She looked at him with the patience of a woman who had been waiting her whole career for the law to catch up to itself. "I would also recommend calling the police chief." Howard Price had the cuffs off in 45 seconds. He made 2 calls in the next 3 minutes. The first was to the verification number on the credential, where an administrator picked up on the second ring, confirmed the identity, and asked in a very tight voice where the Chief Justice currently was. The second call was to the police chief at home on a Saturday morning, which Howard had never done in 20 years and hoped never to do again. The chief arrived at the precinct 22 minutes later. He walked past Furlong without looking at him, went directly to Alicia, and said, "Chief Justice Washington, I am deeply and genuinely sorry." Alicia looked at him steadily. "I know you are," she said. "We'll discuss what that means in a moment." Then she asked for a phone. She had calls to make. The first call Alicia made was to her personal attorney. The second was to a colleague on the state Supreme Court who had the governor's personal number saved in her contacts. The third was brief and quiet and made from a borrowed office with the door closed. And the person on the other end of that call worked in the state attorney general's office and had known Alicia Washington for 21 years. Within 90 minutes of that third call, the Saturday morning had become something the Oak Brook Police Department was entirely unprepared for. The State Attorney General's office contacted the police chief at 10:04 a.m. The governor's chief of staff called at 10:17. The state police liaison, a position that existed specifically for matters involving the judiciary, called at 10:31 and used language that made the chief's legal counsel, who was listening on speaker, write the word crisis on a notepad and underline it twice. By noon, 2 investigators from the Attorney General's office had arrived at the precinct. They were not hostile. They were thorough, which was worse. They requested the body cam footage, the incident report, and the complete personnel file of Officer Brett Furlong. They requested all of these things with the calm efficiency of people who had been given clear authority to ask and who fully expected to receive. The body cam footage was reviewed in a conference room at 12:43 p.m. Both investigators watched it without speaking. When it ended, the senior investigator, a woman named Deputy AG Constance Reed, who had been doing this work for 16 years, looked at the police chief and said, "How long has this officer been on your force?" 12 years, the chief said. "And in those 12 years, how many complaints?" The chief looked at his legal counsel. His legal counsel looked at the floor. 8, the chief said. Reed wrote something down. "We're going to need the files on all 8. Furlong was placed on immediate administrative leave at 1:15 p.m. His union representative arrived at 1:40 and spent 11 minutes with him in a side room. An officer who passed the door afterward said Furlong's voice was loud at the beginning of those 11 minutes and completely silent by the end. The body cam footage was released to the press by the Attorney General's office at 6 p.m. Not leaked, but deliberately and formally released, with a one-paragraph statement that used the phrase, "under active investigation," and the phrase, "full accountability," in the same sentence. By 8 p.m., it had been viewed 4 million times. By midnight, the governor had issued a public statement. By Sunday morning, it was the leading story in every state newspaper and a third of the national ones. The Oak Brook Police Department's legal counsel, who had been at the precinct since 10 that morning and had not gone home, sat in the chief's office at 9 p.m. and said very quietly, "We are going to need more lawyers." He was not wrong. The Attorney General's investigation into Brett Furlong and the Oak Brook Police Department began formally on Monday and did not stop for 13 months. What the investigators found was not buried. It was simply unread. Sitting inside the department's own filing system, logged and organized and completely unexamined, because no one had ever been required to look at it all at once. Furlong's stop records going back 3 years produced a picture that was, by the time the analysts finished with it, impossible to describe as anything other than a deliberate pattern. In the Oak Brook district, a neighborhood that was approximately 68% white, Furlong had made 41 pedestrian and traffic stops. 36 of those stops involved black or minority individuals. Of those 36, 2 had produced citations. The other 34 had produced nothing. No violations, no crimes, no legal basis that anyone could reconstruct from the records Furlong himself had filed. 8 complaints. All 8 were pulled and read in full for the first time since they had been filed. 2 of them were from people who had later moved out of the district and cited the policing environment as a reason. One was from a dentist who had been stopped 3 times in 14 months while driving to his own practice. One was from a woman who had been questioned while sitting on a bench outside the public library. One was from the retired school principal who had been stopped while gardening, whose complaint was still technically pending in a review queue when Alicia Washington was arrested, assigned to no one, going nowhere. 15 people agreed to speak with investigators. They came one at a time and told their stories with the careful detail of people who had been waiting to be asked and had not expected the asking to come. A financial analyst stopped 4 times on the same road in 18 months. A high school principal pulled over for a lane change violation that the traffic camera at that intersection showed had not occurred. A pediatrician who had been made to stand on the sidewalk outside her car for 20 minutes while Furlong ran her plates, her registration, her license, and her insurance, all of which came back clean, all of which he had then logged as suspicious delay in verification. None of them had believed a complaint would matter. Several of them said they had told their children about the stops, had used them as lessons, as warnings, as evidence of something their children needed to be prepared for. That detail appeared in 7 of the 15 interview summaries. It was the detail that Alicia read last, late at night, sitting at her kitchen table with the reports spread out in front of her. She sat with it for a long time. Then she picked up her pen and went to work. The criminal trial of Brett Furlong opened on a Wednesday in April, and from the first day, the courtroom was full. He was charged with deprivation of rights under color of law, the federal civil rights statute that exists specifically for the moment when a badge is used to harm instead of protect. He was also charged with unlawful imprisonment, filing a false police report. His written account described Alicia as uncooperative and aggressive, a characterization that the driveway security camera contradicted so thoroughly that the prosecuting attorney played the footage during her opening statement and then simply stood beside the screen for a moment before continuing, an official misconduct under state law. The defense argued that Furlong had acted in good faith on a suspicious activity report, that the credential was not immediately verifiable in the field, and that the physical contact had been within departmental use of force guidelines. They called 3 character witnesses, fellow officers, a former supervisor, who described Furlong as dedicated and professional. They argued that the public attention surrounding the case had made a fair trial difficult, and that the charges were disproportionate to the conduct. The prosecution called 11 witnesses over 6 days. They presented the body cam footage, the driveway security camera recording, the stop data analysis, the credential verification that confirmed the ID could have been confirmed with a single phone call in under 2 minutes, and 8 of the 15 community members who had come forward. Each of them testified with precision and composure, and the cumulative weight of their accounts, ordinary people, stopped without cause, over and over, for years, settled into the courtroom the way evidence does when it is simply true. And then the prosecution called Chief Justice Alicia Washington to the stand. She was not testifying as the victim. She was testifying as a witness for the state, and anyone who had ever seen her on the bench understood immediately the difference. She sat in the witness chair in a dark suit with a single strand of pearls, and she took the oath with the gravity of a woman who had administered it to others hundreds of times, and she answered every question directly, without hesitation, and with the kind of precision that comes from 32 years of living inside the law. She walked through the stop in order. She cited each statute Furlong had violated and the exact moment of the violation. She described the credential, the phone number printed on it, and the 2-minute call that would have resolved everything before it became anything. She described the handcuffs. She described the ID card on the driveway pavement. The cross-examination lasted 55 minutes. It made no visible progress. The jury deliberated for 10 hours across 2 days. They returned on a Friday afternoon, guilty on all 4 counts. Furlong sat very still. He looked smaller than he had at the beginning of the trial. Not physically, but in some more complete way, as if the certainty that had always held him upright had finally entirely let go. Brett Furlong was sentenced to 4 years in federal prison on a Tuesday morning, and the judge delivered the sentence with the measured gravity it deserved. She noted the falsified report. She noted the credential that Furlong had examined, understood, and dismissed in a single moment that his own body cam had preserved in permanent detail. She noted the 15 community members, the 8 complaints, the 3 years of stops that had produced no crime and considerable harm. She said that the sentence was proportionate not only to what Furlong had done to Chief Justice Washington on that Saturday morning, but to what the record showed he had been doing, with the quiet permission of institutional silence, for 12 years. She said that justice required acknowledging both. Furlong was taken into custody immediately. His pension was forfeited. His law enforcement certification, the one that bore Alicia Washington's signature, was permanently revoked. The civil settlement between Alicia Washington and the municipality was reached 8 weeks later. The figure was not released publicly, but the terms were, because Alicia had insisted on it. The settlement required the immediate implementation of a comprehensive accountability reform, developed in partnership with the State Attorney General's office and subject to federal oversight for 5 years. That reform was called the Washington Accountability Act, passed by the state legislature 4 months after the sentencing with a vote of 31-7. It was the most significant overhaul of state law enforcement standards in 20 years. The act created a mandatory public dashboard displaying every patrol officer's stop records, updated monthly, searchable by name, district, race of the individual stopped, and outcome. It required independent review, not internal review, not peer review, but civilian and legal review with full access to records, for any officer accumulating 5 unresolved complaints within a 3-year period. It established a statewide standard requiring all credentialed identification, judicial, federal, diplomatic, law enforcement from other jurisdictions, to be verified by phone before any further action was taken during a stop, with a target verification time of under 3 minutes. And it created something Alicia had argued for in every meeting, every hearing, and every conversation about the reform over those 4 months. A state office of policing accountability, fully independent of any law enforcement agency, staffed by attorneys, investigators, and community members, with the authority to open investigations, subpoena records, and refer cases for prosecution without waiting for a complaint to work its way through a departmental queue that had, for 12 years, led nowhere. The day the act was signed by the governor, Alicia drove herself home, parked in her driveway, and walked to the end of it in the afternoon light. She looked at the spot where the recycling bins had been. She looked at the place on the pavement where her credential had landed. Then she turned and walked back up to her house, because there was work to do in the morning. And Alicia Washington had never once in her life let the morning catch her unprepared.